Well, good afternoon, everyone. Thank you so much for being here this afternoon for another Lunch with the Friends special program. I'm Chris Knopp, the Executive Director of Friends of the Boundary Waters Wilderness. And Friends of the Boundary Waters Wilderness has been the leader in protecting the boundary waters since 1976. And we're that leader because of you. We're a people-based organization, and you are the strength of the work that we do. Today, our work focuses on three areas: wilderness, people, and community. For the wilderness, there are two mines and one threat, and those two mines are PolyMet and twin metals, and the threat is sulfuric acid runoff from those sulfide mines. And PolyMet is the topic of today's Lunch with the Friends program. Additionally, for people, through our No Boundaries to the Boundary Waters program, we connect students all across Minnesota to the boundary waters through classroom education, online programs, local paddle days, and scholarships for wilderness canoe trips. And if any of you are educators or want to know more about that, please reach out to us. We can provide information about our No Boundaries to the Boundary Waters program. And then finally, for community, we recognize that the communities that are gateways to the boundary waters, Ely, Grand Marais, the North Shore and Gunflint Trail, all of the Arrowhead, but those communities need to thrive and prosper in order for the boundary waters to truly be protected. And so we have a community coordinator based in Ely that is having discussions and conversations with community members all across the region there to find ways in which we can work together to help those communities prosper, whether it's having broadband internet service all across the Arrowhead, or supporting outfitters that may have been impacted negatively by the wildfires that closed down the boundary waters. Well, yesterday was a big day. It was, and it's been a big couple weeks here for all of you who are concerned about clean water in the boundary waters in Lake Superior. Yesterday was the oral argument for the PolyMet wastewater permit before the Minnesota Court of Appeals here. And today we have Evan Nelson, our board member and an attorney with the Maslon law firm, who will analyze the oral argument and provide insight for us. And so we are very fortunate to have Evan here for that. And before I turn things over to Evan, I want to thank our partners in this litigation. We're very grateful for the Minnesota Center for Environmental Advocacy, WaterLegacy, and the Founded Black Band of Lake Superior, Chippewa. So thanks to all those partners that are making this possible to protect our clean water. There's no one organization or one person that is responsible for this, and we're grateful to benefit by these partnerships here. So a couple housekeeping items. I see that a lot of folks have found the chat function there, so please continue to use the chat function at the bottom of your screen there to provide comments. Additionally, there's the question and answer tab where you can provide your questions, and we'll have Evan answer those at the end there, and I'll help curate those questions. So again, thank you, all of you, for being here this afternoon. And without further ado, Evan Nelson. Thank you, Evan, for providing this insight for us.
Thank you, Chris, and good afternoon to everyone who's joining us. Thank you so much for joining us. Thank you for your support. And by support, I mean your financial support. I mean your support in showing up to this event and other events, and honestly, just your spiritual and emotional support. These are difficult legal issues and legal fights that we have, and you guys are really the wind in our sails, and the headway that we're making, and we're making significant headway in these challenges, is because of you. So thank you for that. I want to start the presentation today just to kind of orient ourselves where we are. As Chris mentioned, we are facing two mines that are one threat to the boundary waters wilderness. And we today are talking about the PolyMet mine. There's another mine, the twin metals mine. And you can see on the map on this slide that the twin metals mine is further north, the PolyMet mine is further south. The orange area on this slide is the area that is directly at risk of pollution caused by these mines. As you can see, it would cut a tremendous swath through the Boundary Waters wilderness, and the destruction would be insurmountable and a tremendous tragedy to not only our state, but as you can see, Canada, as it goes further north, and very significantly to the Fond du Lac Band, whose reservation is downstream of the PolyMet mine. That's going to be an important issue later as we talk about this problem. Maya, if you go to the next slide, please. Thank you. So a mine in Minnesota requires the state of Minnesota's permission. And so that's why we talk about permits. The state has to say, yes, you can mine. And there are various permits that every mine has to obtain. The first of which, and the predicate of which, would be the permit to mine, the permit to put a shovel in the ground. That permit was successfully challenged and reversed at the Supreme Court level recently. And that permit no longer exists. PolyMet does not have a permit to mine right now. They have an application, and that application is still pending, but we're still fighting that. The Friends is still part of that fight. I'm not going to talk specifically about that, but there's one thing I want to highlight about that decision. The PolyMet mining design is to capture tailings in a large 900-acre lake tailings basin. And that lake will have reactive waste inside of it. And to prevent that reactive waste from escaping the basin, one of the methods the PolyMet mine will use will be to add a layer of bentonite. Now, bentonite essentially is cat litter. Not perfectly, but just think of it as cat litter. So they are going to line this lake with clay, with cat litter clay. And we pointed out, and the Supreme Court agreed, there is no evidentiary support that this is going to work or that it has worked before. This is a test, a live action test in the Boundary Waters wilderness area that bentonite, fingers crossed, is going to work. Well, that's not sufficient. And the Supreme Court said that isn't sufficient. And so they're going back for what's called a contested case hearing on that issue for the permit to mine. That's going to be important a little bit later, okay? So keep that in your head. The other permits that PolyMet has would be this Clean Water Act permit that we're going to talk about today. There's also a Clean Air permit, which is part of a separate challenge. All of these permits are under challenge, and I believe there's also a Army Corps of Engineers challenge, but I may be mistaken there. Chris, you can correct me if I'm wrong on that. Okay, there is. Thank you. All of these are under court challenge right now, and as I said earlier, we are making significant headway on all of these challenges, which, by the way, almost never have. Environmental organizations rarely get victories when they're trying to use the courts to challenge these permitting decisions. The fact that we're getting these victories is not only because of you, but also because this mine is just not a good idea. It's not well designed. We're not against the concept of mining. We're against the concept of unsafe mining, and we're really against the concept of trying Minnesota as a test to see, God, I hope this works. No, we don't want that here. And that's why we're challenging this mine. If you go to the next slide, please. So yesterday was the oral argument for the Clean Water Act permit challenge that is at the Court of Appeals. In Minnesota, there's a district court or a trial court, and then you can appeal to the Court of Appeals, which is the intermediate appeal, right before you go to the final Supreme Court appeal. Now, you don't necessarily always get to the Supreme Court. The Supreme Court can decide to take a case or not take a case, but you always get your appeal at the Court of Appeals. So this is a huge day. Oral argument is the one time in all of litigation where you can talk directly to the judge about your case. Other than that, it's all written briefs. And you can answer questions from judges that really show what the judges are most concerned about. And you can help them work through those concerns in oral argument. So it's a humongous day. Now, there were actually three decisions that were ultimately at issue yesterday. First, for the Clean Water Act permit, we asked for a contested case hearing. Now, that's a hearing which a judge, not the agency, but a judge will hear the scientific evidence to see, okay, scientifically, is this plan going to work? We asked for that here. One of the issues we asked for was that same bentonite amendment. MPCA, who issued the clean water permit, assumed the bentonite would work because the DNR, who issued the permit to mine, also assumed it would work. So, right, there's kind of like a sequence there, right? DNR thought bentonite was going to work. PCA came in and said, well, DNR said it was going to work, so therefore we think it's going to work too. And our point there was not enough. We need to have some evidence to say that this hypothesis is going to work. The other issue was the ultimate fact that they issued the permit. So we're challenging everything about the permit, all the legal issues with it, and we're going to talk more about that. We also challenged the process the Pollution Control Agency used to make that decision. Now, you may recall there was an evidentiary hearing or a trial back in January 2020. If you don't remember what happened before COVID, I don't blame you, but in January 2020, we had significant evidence and allegations that the PCA had engaged in essentially a cover-up of federal EPA scientists' concerns about this permit. Specifically, we found that the PCA, the Minnesota agency, knew that the federal EPA had concerns about this permit, significant concerns about the permit. Also, MPCA, the state agency here, knew that if EPA sent in written comments, PCA had to respond in writing, and making a written record that later on you and I in the public and people in robes at the Court of Appeals could take a look at. Knowing that, the PCA said, EPA, do not submit written comments. But they didn't want the comments because they didn't want to respond, because they didn't want you to know what the concerns were. The EPA then decided to call and read these comments over the phone. PCA. So PCA knew what these comments were going to be, but for PCA's request, they wouldn't come in. They still didn't make their way into the permit in writing. They were never there. So we had this evidentiary hearing, and there's a lot more to it than that. But fundamentally, that's what it comes down to, is that PCA took action to keep EPA's concerns out of the record. So those were the major issues at play in these appeals. And now what I'll do is go through the arguments that we made, the arguments that WaterLegacy, which is another environmental organization, made, and the arguments that the Fond du Lac Band made. And then I'm going to go through what the PCA argued and what PolyMet argued. And then we're going to talk about some of the questions the court asked of counsel. That's a good kind of indication as to what the court is thinking. But before I do any of that, I want to say, if anyone tells you they can guarantee what a court is going to decide based on an argument, don't believe them for a second. There's no guarantees in litigation. There's no guarantees in the law. But we can be optimistic. We can make some predictions, understanding that they might not be correct. And we can at least understand which way judges may or may not be leaning based on that. The other thing I want to mention before I go into it is, for those of you who listen to the argument, if you came into the argument agreeing with us, and I'm guessing you did, when PCA and PolyMet's lawyers were up, I bet you hated every single second of it. I bet you thought they were the worst people of all time. Keep in mind that if you don't like opposing counsel, that's because the opposing counsel is doing their job. So we need to think about what PCA said and PolyMet said and try to give it some credit to figure out, like, okay, what are they saying? Is that persuasive, or the judge is going to go with it? That makes us better at our argument. It also gives us a better sense of what the court is thinking. So with all that being said, I'm going to start with what MCEA, who represents us as well, was arguing. And we were focused on what we consider to be the state law issues, the Minnesota law issues. The Minnesota law required there to be a contested case hearing, and essentially it's because of that bentonite issue, but more issues than that. We said the Supreme Court looked at the same record on bentonite and said there was no evidence it was going to work. PCA relied on that, and so therefore the PCA, the agency here for this Clean Water Act permit, was relying on something that didn't exist. And that requires the contested case hearing. Fairly straightforward argument. The other thing we argued was that the state of Minnesota regulates groundwater discharge, while the federal government regulates surface water discharge. Now, let's take a break, because that's going to be a confusing distinction. When you hear groundwater, think water table. The aquifers and the waters in the dirt that we live on top of, where we get things like drinking water and where we can get things like municipal water, often comes from that water table. That's groundwater. Surface water is pictured here: lakes, rivers, streams, wetlands. If you actually see the surface of water, then that's a surface water. So the state of Minnesota regulates discharges to groundwater. Federal government, through the Clean Water Act, regulates discharges to surface water. In this permit, I talked earlier about the fact that there was a huge lake that was going to hold tailings, called a tailings basin. There's also something that's called a Category 1 waste pile. Think of it as a big, huge pile of rocks. In both of those instances, the plan is that they will pollute into the groundwater beneath them. And then PolyMet is going to build a ring around that area and hopefully capture whatever pollution they just put into the groundwater. So it's a release and catch, hopefully, plan. Our argument is that there's no provision in Minnesota law where you can release and catch like that. To the contrary, Minnesota law says don't pollute. Don't put pollution into the groundwater unless you have an economic necessity in doing so. And the PCA didn't find a necessity. I'll explain what they argue back in a little bit. But when we think about that groundwater issue under state law, just think about that release and catch plan. The third thing that we argued, excuse me, having to do with state law had to do with that process I talked about earlier. The process by which PCA made its decisions and how that was infected and irregular because of PCA's attempts to keep EPA's comments out of the record. We talked a little bit about that in our argument and in our briefs, and I'm going to talk more about it later when we talk about the judge's questions, because there's some really interesting questions that Judge Jessen was asking related to this issue, and I want to focus on this later. So our argument was focused on state law. The next argument is WaterLegacy's argument. This is Paula McAfee. She was focused on federal law. Now there's two main issues here. And if you listened to the case yesterday, you probably heard a lot about the Maui analysis and Q-bells. I am very sorry about alphabet soup, but you can't do environmental law without lots and lots of acronyms. So I'm going to explain what a Q-bell is. A WQ-bell is a water quality-based effluent limit. It is a scientifically derived number a level at which water is considered impaired and below which water is considered fine. So think of it as the result. A WQBL is the result. And if your permit has WQBL limits, then your compliance with the permit is measured by the result of whether or not you were actually polluting. In the PolyMet permit, there are no WQBLs. There are instead what are called TBELs, technology-based effluent limits, or internal operating requirements. Essentially, all those requirements are what methods are PolyMet using to control pollution. So that's a limitation on how you try, not whether or not you succeed in containing pollution and not polluting, but whether you try. And so if you think about it, QBELs are much more strict and stringent and enforceable because they are just simply, here's the level, is the pollution below it or above it? If it's above it, you don't comply. An operating limit is all about trying. And welcome to more litigation if you try to enforce something like that, because PolyMet can also always say, well, we tried, and that's all the permit really wanted us to do. So Paula was saying that a QBEL is required because the law, a WQBEL is required because the law says if there is a reasonable potential that the impaired surface waters will have pollution and become more impaired because of your project, you have to put them on a WQBEL. So that reasonable potential analysis becomes important. Paula also said that under the Great Lakes Initiative, which is a multi-state compact that has the effect of federal law, if there is any detectable mercury in surface water because of your project, then that is a reasonable potential for pollution, which requires a WQBEL. Essentially because mercury poisoning is incredibly dangerous and incredibly insidious, and so it has the highest, not the highest, but significantly high levels of protection. So that was the QBEL argument. It's all based upon the idea that there's a reasonable potential for pollution, and so we want science to derive a number above which they cannot go. Now the Maui analysis. Now, Maui was a United States Supreme Court case from, I believe, 2020, if not 2019, a very, very recent decision. And in that case, the Supreme Court said that even if pollution is discharged into groundwater first, remember groundwater is state regulated, but then it percolates through the groundwater and becomes surface water, which is federally protected. If you know that that pollution is going to go through state groundwater into federal surface water, Maui says you have to do a clean water analysis of the reasonable potential of that pollution to impair water. For Maui, there was some confusion on this point. There were some federal circuits and some state agencies that were interpreting the Clean Water Act to say if something goes through groundwater, then the Clean Water Act doesn't apply at all. And then there were some, including the EPA itself, who were saying, no, if it goes through groundwater and into surface water, we need to regulate that which goes through groundwater. The Supreme Court clarified the law, did not change the law, clarified the law, and they said ever since 1970s when the Clean Water Act was permitted, this is what it's always meant. It's always meant that we're trying to protect surface water, and if we know that pollution is going through the state groundwater to get there, that's still a pollution we're concerned about. In this case, the PCA did not do an analysis of the groundwater because it was relying on the interpretation that the Supreme Court rejected. So Paula is saying that they need to go back to the drawing board, they being the agency, need to go back to the drawing board and do this analysis because they didn't do it. So those were her arguments. Now I'm going to talk about the band's argument. the Fond du Lac Band of Lake Superior, Chippewa. And if you go to the next slide, please, Maya. Thank you. So the Fond du Lac Band did not really have well, actually, they didn't disagree with any argument that you've heard so far. They agreed with all those arguments. But the Fond du Lac Band has a unique historical right standing in this case. And that is because under treaties and under federal law, specifically the Clean Water Act, the Fond du Lac Band is considered a sovereign state, just like Minnesota's a sovereign state, just like Wisconsin is a sovereign state, despite the Green Bay Packers, it is a sovereign state. So because it's a sovereign state, it is considered a regulator under the Clean Water Act, just like Minnesota's a regulator, just like Wisconsin's a regulator, Fond du Lac Band is a regulator. And in this case, they are a downstream regulator because the pollution is going to occur in the state of Minnesota. It's going to flow through groundwater and surface water that eventually flows through the Fond du Lac Band reservation. And therefore, because it is a downstream regulator, its standards need to be complied with. No different than if Minnesota polluted water that went into Wisconsin. Minnesota would have to consider Wisconsin's standards. Minnesota has to consider the Fond du Lac Band standards. And again, I'm going to talk more about this when we talk about the judge's questions, but this, I believe, wound up being a very powerful and important argument for the court to hear and to understand, because the Fond du Lac Band standards for mercury especially are more protective, more stringent than Minnesota. And the reason that's important here is because mercury accumulates as it goes downstream. Mercury does not go into the water and then kind of dissipate from there and just get less pollutive as it goes downstream. It actually gathers up in fish tissue and in the river as it goes downstream. So if you pollute mercury in the head of a river, it's going to be worse for human consumption and wildlife consumption and wild rights consumption downstream. So that's why it's important. And what's significant here is the PCA did not consider at all the band's water quality standards. They just didn't do it. So that's the significance of the band's argument. Now let's talk about PCA's argument. So the Pollution Control Agency argument, and this is also their argument they use in public, and also the argument that PolyMet uses quite a bit too, is that the PolyMet mine is the most carefully reviewed project in Minnesota history. Okay, it's been reviewed for a long time, doesn't mean it was carefully reviewed, or at least I think there's lots of evidence to say that the carefulness of the review was the care they took in making sure the record didn't include any evidence that was bad about the mine. That's just me. That's not what the PCA said, obviously. But the PCA's argument was that, first of all, let's talk about that groundwater issue, the release and catch. What they say is that the ground underneath the tailings basin and the rock pile is all part of the facility, okay? That's all one big facility. And the facility can't discharge outside of the facility into the groundwater. And here, because that entire facility, and now you got to think of a facility as like a big sphere, right? Like what you can see also contains what's beneath it, and that's the facility. And so therefore, because it's being captured at the edge of that sphere, at the edge of that facility, they're not discharging into the water, into the groundwater, excuse me. When it comes to the argument about Q-bells, they say there's no reasonable potential for these pollutants to impair waters because the permit's going to work. Because the permit says you can't discharge into surface water, therefore there's no reasonable potential. I mean, I think that's a bit like saying my son's room is clean because I told him to clean it. without checking whether it's clean, but that's their argument. They also say that a reasonable potential is not required under the law for various reasons as to mercury and sulfate and the different toxic metals that we're talking about. But in each case, they're saying that that Maui analysis, that groundwater to surface analysis we talked about earlier, that doesn't matter either, because all of that groundwater is being captured by that containment system in the facility. Okay, so they again are assuming that containment system is going to work, and so therefore there's no need to analyze what's going to happen if it doesn't. And then as to the permitting process itself, this is a copy of the letter that was going to be sent from the EPA to the Pollution Control Agency, but then wasn't because PCA asked the EPA not to submit written comments. Their argument kind of boils down to a harmlessness argument. They say that what does this really matter? Because now we all know what the EPA was concerned about. And also, EPA always had the right to object to this petition, which, by the way, is true. Any Clean Water Act permit is issued by a state, and then the EPA has veto power over that permitting decision. And so they're interpreting the fact that EPA did not object to being the same thing as saying EPA was okay with this permit. That's their argument as to these issues. We'll talk about PolyMet very briefly. PolyMet's argument is a complete echo of the PCA's argument. And I'm not saying this disparage their argument. They disagree with the agency, unsurprisingly. Although there's one thing that I thought was interesting to keep in mind. We were talking about QBELs earlier, water quality-based, scientifically derived numbers if you go above your not in compliance with the permit. PolyMet's lawyer interestingly said that if the agency wants to impose those limits, that PolyMet would probably object. I think that was an interesting moment of candor, which shows you that QBELs, scientifically based limits of what is actually occurring, are more stringent, are enforceable, and PolyMet does not want them in the permit. Other than that, they agreed with everything the agency did. The agency was fantastic and did the best job it ever could, is what PolyMet says. That's what it was. All right, so questions from the court. Now, I said earlier in this presentation that this is the one time that you can talk directly to the judge and the one time you can answer the judge's questions. So it's really important to think about what these judges were asking, because that's an insight into what they're thinking. We had 3 judges on our panel. We had Judge Johnson, we had Judge Jessen, and we had Judge Sleater. Judge Johnson was the one who was, if you watched presiding, he was the one who was kind of in charge and kept the time going. And we know from previous experience here at Maslon, is very concerned with what's called the plain language rule of interpreting statutes. His view of the judiciary is a judge has no power unless the legislative body has expressly said, here's what you can do, here's what you can't do. And so he wanted us to point him to direct statutes and direct regulations and think about the exact words that are being used in those statutes and regulations. That's not a good nor bad thing for us. That is just the way that he's thinking about this case. Regardless of if he thinks the mine is a good idea or not, or if he thinks it's going to work or not, if we can't point him to something in statutes that says he's empowered to act, he's probably not going to act. And so because of that interest in what the statute says, he was the one who asked Matt Murdoch, who was arguing for the ban, is the band a state underneath these regulations? Can the band have its own enforceable water quality standards? And Judge Johnson, looking at the statute that Matt was looking at, said, I don't see Indian tribes written here. It just says state. And Matt was then able to take that question and answer it by saying, well, look at these other statutes which define states. And those definitions of states include Indian tribes. That was a really key moment because that tells me that Judge Johnson is taking seriously Matt's argument that the band has its own standards that should have been followed, or at least should have been analyzed, because there's statutory support for that argument. So that was key from Judge Johnson. Judge Sleeter was asking a couple questions that I think are important that we should think about. First, he asked some questions about that bentonite question that relates to the contested case hearing. And he was getting at what are some of the maybe weaknesses or things that are less clear about this case. Because he was saying, isn't the contested case hearing for the permit to mine different than a contested case hearing for a pollution discharge permit? Because the permit to mine has to include how you're going to clean up any pollution. And the bentonite is part of how they're going to clean up and collect pollution, whereas the discharge is just trying to prevent pollution in the first place. And so he was kind of asking, is that a difference that makes a difference? And I think Luis had some very good answers as to why it's not, because essentially, like I said, Pollution Control Agency relied on the DNR, and the DNR was found to have no evidence for its conclusions whatsoever. So they're still pointing at no evidence. Judge Johnson also had some interesting questions. There's some important questions, I think, about the Maui case. And a lot of that discussion, I felt, got very lawyerly. It got very kind of in the weeds on Supreme Court law and federal law and water protection law. The reason why I think that's important is because the judges are now wrestling with that. And I think what we saw was the judges asking Paula McAbee, who was counsel for WaterLegacy, what environmental law meant. And as an appellate lawyer, if the judges are asking you questions as if you're the expert on the law, that's a good position to be in. If you can give a mini like water protection law 101 kind of a presentation to the judges because that's what they want, that means they trust you. And trust and credibility is an incredibly important thing for a lawyer to have before a court. And I believe that Paula McAbee did a great job giving trustworthy, credible, and clear answers to Judge Sleeter's questions. So I think that Judge Sleeter and the other judges too are really, really concerned with what Maui means for this permit. Does Maui mean that they have to do a reasonable potential analysis for the groundwater that's going to turn into surface water down the road? Finally, Judge Jessen, I think I counted 4 times, asked questions about the danger signals or the transparency concerns here. All of those questions were relating to the fact that PCA wanted EPA's records or comments out of those records. To her, now of course she was saying this is hypothetical, let's say we rule this way, but I still think that actually asked the questions a lot is important. To her, that was a danger signal. There's something wrong was happening at the agency here, but she wanted to know, what does it mean? When she was asking questions about what would a remand look like, what instructions would we give the agency, where do you want us to send this? What do you want us to do? All of those questions really boil down to the question of, if we agree with you, what should we do about it? Now, a couple things about that. That's always a great question to understand and a great question to answer, because I think it means the judges on some level agree with you that something is wrong. And so you've kind of gotten past one hurdle. Now here, this is a difficult question for us to answer, because in truth, and if you read our briefs, there are many different things the court is able to do, any one of which would be good for us, but some of them would be way better for us and way more important. And as we worked through our argument, as we practiced, as we thought about this, we realized that the best thing to do here, and this is what we told Judge Jensen, is this needs to be sent back to the Pollution Control Agency so they can reopen the public comment period. And when they reopen the public comment period, that allows EPA to put in its comments, requires PCA to respond to those comments. It also allows comments on these legal issues. It would force PCA to resolve these legal issues. It would force PCA to say how the Maui analysis works. It would force them to contend with the ban's requirements. It would force them to deal with the groundwater question. It would bring them back to the drawing board and do the analysis they should have done in the first place and did not do. So that's where we left that question. And then finally, before we go to the next slide, Maya, I think the most important exchange of the entire argument happened at the very end of the argument. And that had to do with the ban's water quality permits. At the very end, Judge Johnson was asking Matt about whether the band had different standards than the state of Minnesota. And it's a key question, because essentially what Judge Johnson was asking was, what does it matter? If they ignore you, does it matter? And why does it matter? And Matt was able to explain why it matters, because mercury is insidious, because mercury accumulates. The band has ceremonial and substantive fishing rights, treaty rights, historical rights that are implicated with mercury poisoning. And for that reason, the PCA had to consider the band's standards. And then Judge Jessup said, I'm looking at the fact sheet, which is like a document the agency put together that's part of the permit. And she said, now this fact sheet says that the permit doesn't allow for any discharge to protect this state's waters. Does this state mean just Minnesota and not the band? Which Matt said, yes, that's what that means. Emo, because you had two judges focused on the same issue and focused on it in a way that illustrates why it's important and why the PCA was wrong and why we need to have the PCA go back. At the Court of Appeals, you just need two. You don't need three. You need two judges on your side to rule in your favor. So all that said, I don't know what's going to happen next. We'll go to the next slide. All I know is the Court of Appeals by statute has 90 days to issue its decision. That puts the decision likely sometime after Christmas or before January 20th, before Martin Luther King Jr. Day, in that time frame. They could issue it tomorrow. I sincerely doubt it'll be anytime soon. A lot of you might think that's a long time. I'm here to tell you that across the United States, Minnesota is really well known for being timely and fairly speedy on its judicial decisions. In federal courts, there is no time limit, and you can wait for years sometimes before you get your answer. So we have to wait 3 months. After the Court of Appeals issues its decision, I am sure that either side will appeal it, depending on how it turns out, and we would appeal it to the Minnesota Supreme Court, or PolyMet and the agency would appeal it to the Minnesota Supreme Court. Supreme Court, like I said earlier, might take it, might not take it. All of that would happen within about 3 months after the decision is done. If the Supreme Court takes it, then we're probably another year in the Supreme Court. If the Supreme Court doesn't take it, then the Court of Appeals decision stands, and that's the law of the land for this case. It's either going to go back to the agency or, unfortunately, there'd be a bad permit out there. But I really think that we had engaged judges who asked significant and important questions about this case. You could tell that each of the judges had studied these issues, had studied the record, had looked through the briefs very carefully for all sides, and I was impressed and pleased with the level of questioning that we got. Speaking of questioning, I think now is a good time to take some of yours.
Great, thank you so much, Evan. And I want to return to an issue that you brought up that Paula McAbee from the attorney for WaterLegacy discussed, and that was the sort of cumbersome acronym of QBELs here. So we have these water quality based effluent limits. And so for people watching this, those are the numeric limits, and it would be the equivalent of a speed limit on a road. Let's say that the speed limit is 30 miles an hour. And if you go 35 miles an hour, you know you're breaking the law. And what our state regulators, instead of going for something that would be clear, they had the equivalent of these operational limits, so that if you use your signal light and if you use your seatbelt, then you were complying with the law. And basically those operational limits where PCA was not protecting our resources enough, and what the US EPA was trying to make clear in its letter that was never sent to the Pollution Control Agency is that, look, if you just say, wear your seatbelts and use your signal light, you can be going, 100 miles an hour in a school zone and still be complying with, quote, the permit. And so maybe you want to talk about what a permit shield is. And that was brought up during the oral argument, and how the permit can shield someone who's really a polluter.
Yeah, Chris, that's a great analogy as well. I had used the analogy of just if you try, then you pass the permit, as opposed to whether or not you succeed to see if you comply with the permit. Yeah, that does lead into what is often called a permit shield. And the shield protects the permittee, protects the mining company from any liability. Because if there's any disaster whatsoever, the mining company, PolyMet, or Glencore, really, can say, oh, you can't sue us because we were following the permit. You can't force us to pay for cleanup because we were following the permit. And if the permit is written in such a loosey-goosey way that as long as you're trying, then you're following the permit, you've created a shield from any liability for this mining company. And mining companies are notorious for privatizing profit and socializing loss. They are notorious for extracting, taking profits for it, and then leaving states and citizens and taxpayers with humongous cleanup bills. We don't have time to go through the examples right now, but suffice it to say that there are several states that have $1 billion cleanup bills, and the mining company is gone bye-bye. So that's why permit shield is important. That's why QBELs, it sounds very technical. It is very technical. It's also incredibly important. So I saw a question here that I want to handle first. So someone talks about where does Glencore sit here. Glencore is not on the permit because PolyMet obtained the permit before Glencore bought up enough shares to become the controlling owner of PolyMet. It's a shell game. PolyMet gets the permit, and then the company on the permit is PolyMet, which is owned owned by Glencore. If there's some sort of issue, then PolyMet declares bankruptcy. Glencore is fine. All the profits have been captured and they're sitting in Switzerland in Glencore. And PolyMet, the legal fiction of PolyMet, is gone. So that's why it's important to try to get Glencore on the permit, to put them on the hook. We have some of those issues being raised in the permit to mine. That's not really an issue here, but it's important to be thinking about that. Someone else asked a really good question about the administrative law judge. In a contested case hearing, you are before an administrative law judge. The administrative law judge hears testimony and issues findings of fact, conclusions of law, and gives you an order. That order then goes back to the commissioner. And as the person who asked the question pointed out, the commissioner or the agency, the pollution control agency, can completely ignore what the administrative law judge said. However, if they did ignore it, then when you go to court later on, you can point out that delta and you can point out that difference to say the agency was acting in an arbitrary and capricious way by ignoring the findings of the administrative law judge. So while legally they do not have to follow the ALJ, they do so at their own peril. That's why a contested case hearing is important. I see a question here about the layers of protection analysis, and I'm going to be frank, I do not know that. I will look into that. Thank you, Robert, for pointing that out. I'll take a look at that. I do not recall it from my legal research in this case. That doesn't mean it's not there. And so we'll see what I can look. Someone else pointed out about Glencore that Glencore is internationally renowned bad actor. That is absolutely true. There is a deep irony in a lot of mining proponents' position. And one of the things you will hear them say is if we don't get the mine here, then we have to rely on other places that have horrible human rights abuses, like, for example, the Congo. Guess who owns the mine in the Congo? It's the same people who own this mine. So it's very duplicitous and sarcastic, really, of them to use that argument. We have some thoughts and efforts to maybe try to make it so that people with proven bad records have more difficulty getting permits or have to prove some sort of a showing that they're no longer bad before they do. That's not really related here, but part of the larger issue that we see with mining. Another issue we see, and a fundamental issue that we see, and Maya, if you can go to the next slide on the PowerPoint, is the fact that these mines don't work. Copper sulfite mines produce acid mine drainage, and they especially don't work in water-rich environments. And what PolyMet and the agencies that are blessing and PolyMet is trying is to use Minnesota as a testing ground to see if this brand new plan will work. And what we're saying is Minnesota is not a laboratory, especially not the boundary waters, but really just anything in Minnesota. I mean, if it's Wilmer, if it's in Moorhead, the boundary waters, Lake Superior, or in downtown St. Paul, this is not the place to test out mines that have never worked before. And so we have some legislative partners, and we're working with them to have introduced the Prove It First bill, and it has been introduced. There currently has not been any hearings on this bill. It's been kind of gummed up in legislative kind of backroom policy-making procedures. And so someone in the comments said, can we put pressure on legislators? And yes, and here is where you can do that. You can ask them to have a hearing on Prove It First bill. Have a hearing on whether or not Minnesota is appropriate to test out unsafe mines. And you can learn more information about Prove It First on the Friends of the Boundary Waters website. If you drive around the Twin Cities area or in Minnesota and see someone with a lawn sign that says Prove It First, knock on the door, ask them, introduce yourself and say, hey, you and I just became best friends. Let's talk about this bill. We're trying to build this up. There we go, Chris. Chris has got it right there. And you can also, talk to Chris, reach out if you want a lawn sign of your own. That's the pressure we want, and that's the pressure that's going to be helpful. And the legislative body is to get Prove It First passed. I see we have a couple more minutes. Thank you, Robert. I'll take a look at that. Yeah, I think those are all the questions that unless Chris or Maya, if I missed something, please let me know.
No, thank you, Evan, for that thorough analysis and walking us through yesterday's oral argument here. Building on a couple things, again, for everyone listening, we really need your help to pass Prove It First. We have 4 tools in our toolbox. We have litigation, we have legislation, citizen action, and through our affiliate, our Friends of the Boundary Waters Action Network, we can work in the political sphere as well. And so, as Evan mentioned, it's been gummed up in the legislative process. What that means is that the Republican leadership in the Senate and the DFL leadership in the Minnesota House of Representatives have prevented there to be any hearings on Prove It First. And so it's and so that's one of the big challenges for all of us on the phone to realize that this has been a bipartisan bottleneck created to really suppress these efforts to protect our environment. So we really need you to be supportive of Prove It First, and you can reach out to Maya, who'll put her email address in the chat button there, to be part of our Citizen Action Network and to contact her to know where your legislator stands on this, and the specific email and phone numbers you can use to contact your legislator. You can also reach out to Maya to get one of these Prove It First yard signs that you can place in your yard as well. And there is, as I mentioned, that 4th tool in our toolbox, and we'd like you to join us next week at Lake Monster Brewing on Wednesday at 6 o'clock from 6 to 7:30. We're going to have a gathering for our Friends of the Boundary Waters Action Network. We would love to see you there in St. Paul at Lake Monster Brewing. And Maya, do you have a panel for that where you can show the address perhaps for that? We hope to raise some funds for our political work there, but we also just want people to come together for that to continue the conversations that we're having here right now on our litigation work and the ways we can protect the boundary waters in Lake Superior. But please, again, Wednesday, November 3rd from 6 to 7:30 at Lake Monster Brewing in beautiful St. Paul here. So again, I want to thank Evan for your time and great analysis into the PolyMet wastewater permit oral argument yesterday. And so in 90 days, we'll have that, within 90 days, that decision. And in about 90 days, we're actually going to have our first precinct caucuses. And those are on February 1st, 2022. And we need you to be Prove It First delegates. So we want people to participate in our electoral process, so we can have legislators that are supportive of Prove It First. And so we want people to show up at their precinct caucuses on February 1st and become a Prove It First delegate, so that you'll continue throughout the process there, the political process, to advocate for Prove It First. And by reaching out to my swope here, you can learn more about that, and we'll have some special sessions directed just to that. But so as you think 90 days out for this decision, also think about 90 days out for becoming a Prove It First delegate, where you can put your people power to work. So again, thank you to all of you for being here this afternoon. You again are the strength of the Friends of the Boundary Waters Wilderness here. And thank you again, Evan, so much for your time. So have a great afternoon, and we are grateful for your support. Thank you so much. Goodbye, everyone.